The prestigious Harvard Law School auditorium descended into an electric hush as Supreme Court Justice Elena Kagan abruptly shifted from her planned remarks, launching an unanticipated and incisive critique aimed squarely at Representative Jasmine Crockett. The annual Distinguished Lecture on Congressional Power Dynamics had drawn a packed audience. Law students, professors, and prominent legal practitioners, all eager to witness both Justice Kagan and the newly elected Texas Congresswoman share a stage for an elite discussion on the shifting currents of authority among America's three governmental branches. Representative Crockett, I must challenge your earlier interpretation of this court's recent rulings on the Commerce Clause, Justice Kagan declared, her voice imbued with the surgical precision and calm authority that had long defined her as one of the judiciary's sharpest intellects. You've suggested our decisions are driven by political ideology rather than genuine constitutional reasoning. But wouldn't it be more accurate to admit that Congress has steadily retreated from its constitutional duty by drafting vague statutes, legislation so ambiguous that it effectively delegates critical policy choices to unelected bureaucracies? In doing so, it leaves the courts to draw the very lines elected representatives should have delineated from the beginning. This reframing, portraying Congress's increasing reliance on administrative agencies as the true source of institutional imbalance rather than judicial overreach, stood in direct opposition to Crockett's earlier remarks criticizing recent Supreme Court opinions curbing federal regulatory power. For nearly 40 minutes, the panel discussion had unfolded with the polite civility expected of an academic exchange, its speakers offering measured reflections on the tensions between Congress, the judiciary, and regulatory institutions. That calm equilibrium fractured, however, when Crockett responded to a question about the court's recent limits on agency authority. In deliberate and precise terms, she had accused the justices of what she called selective originalism, the inconsistent application of historical interpretation in evaluating Congress's constitutional powers. My concern isn't with legitimate disagreement about the proper reach of regulatory authority, Crockett explained, but with the court's uneven use of history, invoking it to expand judicial control while simultaneously restricting congressional authority derived from identical constitutional language. This methodological inconsistency, she argued, projected the image of a court guided more by desired outcomes than by principled uniformity. That pointed observation that the court's so-called originalist framework imposed historical constraints on Congress while disregarding similar limits on judicial power had clearly struck a chord with Justice Kagan, whose own jurisprudence had long reflected both unease toward judicial activism and caution toward unchecked bureaucratic expansion. Her question, redirecting scrutiny toward Congress's drafting practices rather than judicial motives, injected a rare spark of tension into a setting where direct confrontations with sitting justices were almost unheard of. The audience, composed largely of seasoned lawyers, professors, and attentive students, sensed the weight of the moment and fell into complete stillness as Representative Crockett prepared her reply. Though in her first term on Capitol Hill, Crockett had already earned a reputation as a meticulous and substantive legal thinker, one whose preparation often exceeded expectations for even senior legislators. Yet facing an open challenge from a Supreme Court Justice of Kagan's formidable intellect and institutional stature was an entirely different order of difficulty, one that left even veteran observers unsure how she would navigate the exchange. Crockett drew a measured breath, quietly straightened her notes, and met Kagan's gaze with the steady composure that had marked her demeanor throughout the panel. Justice Kagan, she began, her tone respectful yet unwavering, I sincerely appreciate the rigor of your challenge. The statement carried a genuine humility that acknowledged both Kagan's authority and the validity of her question. You've raised an important issue about Congress's drafting practices, one that deserves genuine reflection. Congress bears undeniable responsibility for much of the institutional imbalance we see today, and I've personally supported efforts to tighten legislative precision so that less interpretive burden falls upon the regulatory agencies. That opening, acknowledgement, accepting Kagan's critique, rather than deflecting it, immediately shifted the tone of the conversation from confrontation to collaboration. It drew the audience back from the edge of discomfort into an atmosphere of earnest intellectual engagement. As Kagan's expression softened in quiet approval, Crockett continued, However, I think both our branches face comparable institutional challenges that require mutual recognition, not one-sided correction. Just as Congress must legislate with greater clarity, the the judiciary must also examine whether its modern restrictions on commerce, power, applied selectively to contemporary issues while simultaneously expanding judicial oversight, create interpretive inconsistencies that weaken constitutional coherence. Her voice remained steady, controlled, never raised, but every sentence landed with unerring precision. "The historical record is quite revealing," she said, because the early court showed remarkable restraint in second-guessing Congress's economic determinations. Chief Justice Marshall, in Gibbons v. Ogden, declared that Congress's commerce power is complete in itself, exercised to its utmost extent, and subject only to the Constitution's limits. That broad interpretation of congressional authority endured for generations before later courts imposed narrower readings. So if modern jurisprudence now limits Congress based on 18th-century understandings while simultaneously expanding judicial review beyond its own historical confines, we face the very inconsistency that fuels today's legitimacy crisis. Then, with flawless timing, Crockett delivered her most compelling observation. "Institutional legitimacy," she said slowly, "requires admitting that neither branch has preserved perfect fidelity to history. Congress has, at times, drafted too broadly. The judiciary, likewise, has ventured beyond historical limits. Recognizing this shared evolution, rather than assigning unilateral blame, may be the only way to restore the balance both branches claim to protect, because true constitutional legitimacy depends on principled consistency, not on which institution wins the interpretive contest." Her conclusion settled over the room like a solemn echo. The auditorium remained utterly still as listeners absorbed the weight of her words. A moment that legal analysts would later call a masterful pivot, one that gracefully acknowledged Congress's culpability while subtly holding the judiciary to its own professed standards. "So yes, Justice Kagan," Crockett concluded, "I wholeheartedly agree that Congress must refine its legislative craft, but perhaps both branches would benefit from recognizing that selective historical reasoning, no matter who employs it, undermines the coherence of our Constitution. What sustains our constitutional order isn't institutional victory, but interpretive integrity. It's the steadiness of principle, not the pursuit of preferred results, that inspires public trust in our system of self-government." The transformation was complete. From what had begun as a conventional academic forum to an uncommonly substantive exchange on constitutional method, scholars would later describe it as a rare instance of genuine institutional dialogue, a moment where mutual respect illuminated the path between critique and collaboration. Justice Kagan's expression, now touched with both admiration and contemplation, seemed to reflect that realization. The tension in the hall dissolved into a quiet acknowledgement that something exceptional had just occurred. A freshman congresswoman offering a nuanced constitutional critique to a sitting Supreme Court justice, without a trace of disrespect, without political grandstanding, but through disciplined reasoning and fidelity to principle. Before we dive deeper into this explosive confrontation that has everyone talking, don't forget to like this video and subscribe to our channel. Hit that notification bell so you never miss our in-depth analysis of the most revealing moments in constitutional dialogue that mainstream media often glosses over. Now let's get back to the remarkable exchange where Representative Jasmine Crockett's measured response to Justice Elena Kagan's direct challenge completely transformed what could have been an uncomfortable institutional confrontation into a substantive examination of constitutional methodology that left the Harvard Law audience stunned. With its balanced insight and perfect institutional respect, Jasmine Crockett's journey to that pivotal moment at Harvard Law School reflected an unconventional trajectory in American politics and constitutional discourse. Elected to Congress in 2022 following merely one term in the Texas state legislature, the 41-year-old attorney had rapidly established herself as one of the most substantive voices on constitutional questions, despite her junior standing in Washington. What political commentators frequently overlooked when emphasizing her relatively recent emergence on the national stage was her extensive background in constitutional litigation and institutional analysis preceding her entry into politics. Before seeking office, Crockett had built a reputation as a meticulous legal advocate who emphasized methodological consistency rather than outcome-driven argumentation, recognizing that constitutional legitimacy ultimately depends on principled coherence across cases rather than selective application appearing to follow preferred results. Her approach to constitutional analysis had always prioritized interpretive consistency across institutions rather than partisan advantage, understanding that legitimate constitutional governance requires principled methodology transcending outcomes, regardless of which branch applies it. Though new to national political debates, she approached constitutional questions with the same methodical attention to interpretive consistency that had characterized her legal career, where persuasive advocacy depended on demonstrating principled coherence rather than selective application. Justice Elena Kagan, by contrast, had established herself over 12 years on the Supreme Court as one of its most intellectually formidable members with particular expertise in administrative law and separation of powers questions. Before her appointment to the court, Kagan had served as the first female Solicitor General of the United States, and as Dean of Harvard Law School, building a reputation for both brilliant legal analysis and pragmatic institutional understanding. Throughout her judicial career, she had developed a jurist credential approach, combining methodological rigor with institutional pragmatism, often challenging both excessive administrative authority and judicial overreach while emphasizing the court's limited role in policy determination. Justice Kagan's effectiveness comes from her ability to engage constitutional questions with both doctrinal precision and institutional awareness. One former Supreme Court clerk had observed privately, her questions often probe the institutional consequences of constitutional interpretations rather than abstract principles alone, focusing particularly on how different approaches affect the balance between branches and the coherence of constitutional governance across diverse contexts. This institutional focus makes her particularly attentive to questions about both congressional delegation and judicial restraint, seeing them as complementary aspects of maintaining constitutional balance rather than isolated doctrinal questions. The Harvard Law School distinguished lecture that brought them into this extraordinary exchange had been organized as an academic exploration of separation of powers in modern governance, with particular focus on tensions between congressional authority, judicial review, and administrative implementation. The specific panel featuring Justice Kagan alongside Representative Crockett and several constitutional scholars had been designed to examine how these institutional relationships had evolved in response to modern governance challenges and whether current arrangements maintained proper constitutional balance. For 40 minutes, the panel discussion had maintained the collegial tone typical of academic settings, with participants offering measured assessments of institutional tensions reflecting thoughtful analysis rather than partisan positioning. Justice Kagan had provided particular insight into administrative law questions, noting both the practical necessity of delegation in complex regulatory domains and the constitutional concerns about excessive administrative authority without adequate legislative guidance. The dynamic shifted when Crockett, responding to a question about recent Supreme Court restrictions on agency authority, had methodically critiqued what she characterized as selective originalism in Commerce Clause interpretation. "My concern isn't legitimate constitutional debate about regulatory boundaries, but the court's inconsistent application of historical standards that expand judicial authority, while simultaneously restricting congressional power authorized by the same constitutional text. This interpretive inconsistency, applying historical constraints to congressional authority, while expanding judicial power beyond historical limitations, creates the appearance that constitutional methodology follows preferred outcomes rather than principled consistency. This critique suggesting the court's originalist approach applied historical constraints to congressional power while ignoring similar historical limitations. Judicial authority represented a substantive challenge to the methodological consistency of recent Commerce Clause jurisprudence rather than simply disagreeing with specific outcomes. By focusing on interpretive consistency rather than preferred results, Crockett had framed her critique in terms of constitutional principle rather than policy disagreement. Precisely the kind of methodological focus that Justice Kagan's own jurisprudence had often emphasized. Despite reaching different conclusions about specific applications, Justice Kagan's unexpected direct challenge, redirecting responsibility toward congressional drafting rather than judicial interpretation, created a moment of tension precisely because it came from a justice whose own dissent had often raised similar concerns about methodological inconsistency in Commerce Clause cases. Representative Crockett, I must take issue with your earlier characterization of the court's recent Commerce Clause jurisprudence. She had stated, "You've suggested our decisions reflect political preference rather than principled constitutional interpretation. But wouldn't the more accurate assessment be that Congress has increasingly abdicated its constitutional responsibility by drafting vague legislation that improperly delegates fundamental policy choices to administrative agencies, effectively forcing courts to establish boundaries that legislators themselves should have clearly defined?" This question framing congressional overreliance on administrative delegation as the root problem rather than judicial overreach represented both institutional defense and substantive challenge. By suggesting that congressional drafting practices rather than judicial interpretation created the current imbalance, Justice Kagan had redirected responsibility while simultaneously acknowledging legitimate concerns about institutional balance that Crockett had raised. This combination of institutional defense and substantive engagement created a particularly challenging response situation, requiring acknowledgement of valid congressional criticism while maintaining the substantive critique of interpretive inconsistency that had prompted Justice Kagan's intervention. When Crockett began her response, her opening words acknowledging the legitimacy of Kagan's critique, rather than defensively rejecting it, immediately established a tone of substantive engagement rather than institutional confrontation. Justice Kagan, I deeply appreciate your thoughtful challenge. You've raised a legitimate concern about congressional drafting that deserves serious consideration. Congress absolutely shares responsibility for the current institutional imbalance, and I've personally advocated for more precise legislative language that would reduce the need for extensive regulatory interpretation. This initial acknowledgement, accepting congressional responsibility rather than defensively redirecting blame, demonstrated both institutional maturity and substantive engagement with Justice Kagan's valid critique. By explicitly agreeing that Congress absolutely shares responsibility and noting her own advocacy for more precise legislative language, Crockett had demonstrated willingness to acknowledge legitimate criticism rather than engaging in institutional defensiveness that would have undermined her credibility and reinforced perception of partisan positioning. As Justice Kagan's expression registered appreciation for this acknowledgement, Crockett continued by reframing their disagreement in terms of mutual institutional responsibility rather than unilateral blame. However, I believe both branches face similar institutional challenges that require mutual recognition rather than unilateral correction. Just as Congress must draft more precise legislation, courts might consider whether commerce power limitations selectively applied to modern regulatory questions, while simultaneously expanding judicial review beyond historical constraints creates interpretive inconsistency that undermines constitutional coherence. This reframing suggesting both branches face similar challenges of maintaining interpretive consistency shifted the discussion from institutional blame to mutual responsibility for constitutional coherence. By acknowledging congressional responsibility while gently suggesting that courts might similarly examine their own selective application of historical constraints, Crockett had established a framework of mutual institutional improvement rather than unilateral criticism, a far more constructive approach that demonstrated commitment to constitutional principle, regardless of institutional advantage. Without raising her voice, but with remarkable precision, she then provided specific historical context that highlighted the court's own evolution beyond founding-era limitations. The historical record shows the early court exercised extraordinary restraint in overturning congressional economic judgments with Chief Justice Marshall establishing in Gibbons that commerce power is complete in itself may be exercised to its utmost extent and acknowledges no limitations other than are prescribed in the Constitution. This robust view of congressional commerce authority persisted for over a century before modern restrictions developed, suggesting that limiting congressional commerce power based on founding-era understanding while simultaneously expanding judicial review beyond founding-era limitations may create precisely the methodological inconsistency that causes the legitimacy concerns we're discussing today. This specific historical context, noting the court's own significant evolution beyond founding-era limitations on judicial review, while simultaneously restricting congressional authority based on historical limitations, directly addressed the methodological inconsistency that had been the substance of her original critique. By specifically citing Gibbons and the court's century-long deference to congressional commerce judgments, Crockett had provided concrete historical evidence that the court itself had evolved significantly beyond founding-era limitations, raising legitimate questions about selective application of historical constraints to congressional authority while expanding judicial power beyond similar historical boundaries. Then, with perfect timing that left the room momentarily breathless, she added the most substantive insight about mutual institutional responsibility. Perhaps most importantly, institutional legitimacy requires acknowledging that neither branch has maintained perfect historical fidelity. Congressional drafting has often grown excessively broad, while judicial interpretation has often extended beyond historical boundaries. Recognizing this mutual evolution, rather than assigning unilateral responsibility, might help restore the institutional balance both branches genuinely seek to maintain. After all, constitutional legitimacy ultimately depends on principled consistency that transcends preferred outcomes, a standard that should apply equally to congressional legislation and judicial interpretation. This balanced assessment acknowledging evolution in both branches rather than claiming perfect congressional fidelity established a framework of mutual institutional improvement rather than competitive blame allocation by explicitly acknowledging that neither branch has maintained perfect historical fidelity, while suggesting that constitutional legitimacy ultimately depends on principled consistency, transcending preferred outcomes. Crockett had articulated a standard that applied equally to both institutions rather than selectively criticizing either, precisely the kind of principled consistency her critique had originally emphasized. The auditorium remained completely silent, as she concluded with a masterful redirection that both acknowledged congressional responsibility and gently highlighted the court's own selective historicism. So yes, Justice Kagan, I absolutely agree that Congress must improve legislative precision, but perhaps both branches might benefit from mutual recognition. That selective historical application damages constitutional coherence, regardless of which institution applies it. What strengthens our constitutional system isn't institutional victory, but interpretive consistency that builds public confidence in constitutional governance rather than methodological flexibility that appears to follow preferred outcomes. This concluding framework, emphasizing mutual institutional improvement rather than competitive advantage, completed her transformation of what might have been a confrontational exchange into substantive dialogue about constitutional methodology. By explicitly agreeing that Congress must improve legislative precision, while suggesting both branches would benefit from consistent methodology, Crockett had demonstrated commitment to constitutional principle regardless of institutional advantage, precisely the kind of principled consistency her critique had originally emphasized. The complete transformation from what had appeared to be a differential academic panel to a substantive exchange about constitutional methodology that highlighted interpretive inconsistency while maintaining perfect respect created what constitutional scholars would later describe as an extraordinary moment of institutional dialogue. Asked Justice Kagan's expression reflected both surprised appreciation and thoughtful consideration of this unexpected response. The tension in the room gave way to a collective recognition that they had witnessed something remarkable, substantive constitutional critique, delivered with perfect institutional respect that focused on methodological principle rather than partisan advantage. Representative Crockett, Justice Kagan, responded after a moment's thoughtful consideration. You make a fair point about methodological consistency that I think deserves serious consideration from both branches. While I maintain that congressional drafting bears significant responsibility for current imbalances, your observation about selective historical application raises legitimate questions that courts should take seriously. Perhaps the best path forward involves both more precise legislation and more consistent judicial methodology that acknowledges institutional evolution rather than selectively applying historic limitations. Constitutional dialogue benefits when both branches engage these questions with the kind of principled focus you've demonstrated today. This response, acknowledging the legitimacy of Crockett's methodological critique while maintaining her view on congressional responsibility, demonstrated precisely the kind of substantive engagement across institutional boundaries that constitutional governance requires. Rather than dismissing critique from a junior congresswoman or defensively rejecting her observations, Justice Kagan had engaged the substantive point about methodological consistency while maintaining her position on congressional drafting. Exactly the kind of principled dialogue that strengthens constitutional governance regardless of specific disagreements about particular applications. For the remainder of the panel, a noticeably different dynamic emerged among the participants. While substantive disagreements about specific constitutional questions remained, the discussion reflected greater attention to methodological consistency across institutions rather than competitive institutional positioning. Most notably, both Justice Kagan and Representative Crockett referenced each other's insights multiple times, building on shared concern for constitutional coherence despite different perspectives on specific applications, creating what several observers later described as a model of substantive constitutional dialogue across institutional boundaries. "What we just witnessed was extraordinary," said one constitutional law professor afterward. Representative Crockett didn't merely respond effectively to Justice Kagan's challenge. She transformed what could have been competitive institutional positioning into substantive dialogue about constitutional methodology that applied consistent standards to both branches, rather than defensively rejecting criticism of Congress or aggressively attacking the court. She acknowledged legitimate concerns about congressional drafting while maintaining principled critique of methodological inconsistency, regardless of which institution applies it. That approach, focusing on constitutional principle rather than institutional advantage, demonstrated precisely the kind of principled engagement that constitutional governance requires across institutional boundaries. By evening, clips of the exchange had gone viral across legal education and governance platforms. Crockett-Kagan exchange models, constitutional dialogue, began trending in legal circles with TISL scholars and governance experts, noting both the substantive insight about methodological consistency and the perfect institutional respect that had characterized their interaction. This exchange reveals something profound about constitutional governance, observed one constitutional law professor. Legitimate constitutional dialogue requires both substantive engagement with institutional criticism and principled consistency that applies regardless of institutional advantage. What made this interaction so remarkable wasn't just its substantive quality, but its demonstration that constitutional principle can transcend institutional positioning when participants genuinely engage methodological questions rather than simply defending their branch's prerogatives. By acknowledging legitimate criticism of Congress, while maintaining principled critique of judicial methodology, Representative Crockett established a framework for constitutional dialogue based on consistent principle rather than institutional advantage. Precisely what constitutional governance requires in an era of increasing institutional polarization. If you found this breakdown of one of the most substantive exchanges in recent constitutional dialogue informative, please like this video and subscribe to our channel. Hit that notification bell so you never miss our in-depth analysis of revealing moments that demonstrate how principled consistency can strengthen constitutional governance across institutional boundaries. Leave a comment below with your thoughts on methodological consistency and constitutional interpretation and the importance of applying consistent standards regardless of which institution benefits in particular cases.